The Judiciary Act of 1789 charted a middle path between the strong Federalist version and the anti-Federalist version. It created 13 district courts, one for each state, and then there would be 3 circuit courts. The Eastern, which included New England and New York. The Middle, which included New Jersey in the north, south to Virginia/Kentucky, and the Southern, which included the Carolinas and Georgia. The Judiciary Act also stipulated that the Supreme Court would consist of 5 associate justices and 1 chief justice. In the early years after the act was passed, the Supreme Court only convened twice a year for 2 weeks at a time. So the Supreme Court met for a grand total of 4 weeks in the early days after the Judiciary Act of '89 was passed and signed into law. The justices spent most of their time riding the circuit, as it became known, or sitting as judges in the circuit courts that I mentioned a moment ago, which acted as courts of appeals do now. And these circuit courts served as national trial courts with authority over high-profile crimes and cases that had out-of-state or foreign plaintiffs. The Supreme Court was not initially expected to do a whole lot. And in fact, by 1801, it had heard a grand total of only 87 cases in 12 years. Since 2005, for some perspective, the Supreme Court has heard an average of about 75 cases each year.